And the Constitution of the Federal Republic of Nigeria 1999 as amended, which mandatorily requires the second respondent to score not less than 1/4 or 25% of the lawful votes cast at the election in each of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja. That it may be determined that the second respondent was at the time of the election not qualified to conduct the said election, to contest the said election. That it may be determined that the first petitioner, having scored the majority of lawful votes cast at the presidential election on Saturday, 25th February 2023, be returned as the winner of the said election and be sworn in as the duly elected president of the Federal Republic of Nigeria. In the alternative, number 5, an order directing the first respondent to conduct a second election that is run off between the first petitioner and the second respondent. In the further alternative, 6, that the election to the office of the President of Nigeria held on the 25th of February 2023 be nullified and a fresh election rerun ordered, and any further reliefs as the court may deem fit to make in the interest of justice. Upon being served with the petition, all the respondents joined issues with it by filing their respective replies, incorporating preliminary objections, and made other applications. Some of the applications filed by the party were heard and rulings delivered at the pre-hearing stage, while some were heard and rulings on them reserved till the time of the judgment of the court. On 6 use an electronic means in collating or transferring of elections result. Rather, that INEC is at liberty to prescribe the manner in which the election result will be transmitted. That by Section 287(3) of the 1999 Constitution, all authorities and persons are bound to enforce the terms of the judgment until set aside by an appellate court. It submitted that all through the gamut of the Electoral Act, the appellants were unable to refer to the lower court a single provision which prescribed electronic collation of result or even electronic transmission of results, and that was why the court below held that the petitioners were unable to prove that the Electoral Act or guidelines made it mandatory for electronic collation system. It submitted further that the appellants failed to show that the result collated was different from the one they perceived belonged to them. Learned Soul submitted finally that the Electoral Act 2022, the INEC regulations and manual, points irresistibly to a manual collation of results, contrary to electronic collation touted by the appellants. The reason being that by paragraph 93 of the regulation, the only circumstance where electronic copy of results becomes relevant is where there is no hard copy of the result. Then the electronic copy can be resorted to during collation. Learned Counsel Olanik Bekun urged this court to resolve this issue against the appellants. In his submission, Chief Olujimi SN, or the third respondent, submitted that the appellants seem to have admitted their failure to prove allegation of non-compliance when they pleaded with this court to depart from the earliest established legal position that non-compliance be proved on polling unit basis. He submitted that there is nothing compelling presented by the appellants to warrant a departure from the established legal order, relying on Wike and Peter's side, Belgore and Ahmed citations supplied. He urged the court to decline the invitation. According to Leonard Silk, any agreement for relaxing the established standard of proof of allegation of non-compliance must not be driven by sentiments and cavalier presentation of a case seeking to overturn the will of millions of the electorate in a presidential election. The court below held that the IREP portal is not a collation system. This court in Oyetola and INEC made it clear that there is a difference between a collation system and the IREP portal, though both are part of the election process. Whereas the election system is made up of the centers where results are collected at various stages of the election, the INEC result viewing portal is to give the public the opportunity to view the polling unit results on the election day. What this means is that where the IREP portal fails, it does not stop the collation of results, which up to the last election was manually done. The failure or malfunctioning of the IREP deprives the public and even election administrators and monitors the opportunity of viewing the portal and comparing the result collected with the ones transmitted into the IREP. Truth must be told, the non-functioning of the IREP may also reduce confidence of the voting public in the electoral process. My lords, the Electoral Act empowers the first respondent to determine the electronic device to be used during election and their purpose. The lower court held that the IREP is not a collation system, and I agree. I refer to paragraph 93 of the First Respondents Guidelines and Regulations for Election, which revised that, and I quote, where the INEC hard copy of collated results from the immediate lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the IREP portal to continue collation. When none of these exists, the collation officer shall ask for duplicate copies issued by the Commission to the following in the order below. 1. The Nigeria Police Force, and 2. Agents of political parties. End of quote. Paragraph 93 of the First Respondents Guidelines and Regulations reproduced above shows clearly that recourse to the electronically transmitted result for the purpose of collation will only arise where the hard copy of the result sheet does not exist. Given when the electronically transmitted result or the result on the IREP portal does not exist, the Commission will ask the copies handed over to the Nigeria Police or agents of political parties. The elaborate arrangement made by the first respondent for collation of results is to make sure that at every point of collation, there is a result either from the hard copy with INEC or the electronically transmitted copy or the IREP portal copy or a hard copy given to the Nigeria Police, and finally, or a copy given to political parties. I think I can confidently say, and in agreement with the respondents, that the unavailability of the election results on the IREP portal, for whatever reason, cannot be a ground upon which an election could be nullified, particularly as it is not the case of the appellants that the hard copies of the result sheets did not exist at any level of collation. My lord, having failed to prove its petition by conventional method known to this court, The appellants urge this court to depart from several decisions of this court on ways of proving non-compliance. They have not shown that those judgments were reached per incuriam or that there was any miscarriage of justice. See some cases cited. Section 137 of the Electoral Act, relied upon by the appellants for their failure to prove non-compliance in the manner we are used to, provides, and I quote, "It shall not be necessary for a party who alleges non-compliance with the conduct of election to call oral evidence if originals or certified true copies manifestly disclose the non-compliance." End of quote. The above provision has not absolved a petitioner of the need